Do bank accounts with beneficiaries have to go through probate? Hello, I'm attorney Thomas Burton, and that's today's question. I'm an estate planning and asset protection attorney here in Wisconsin, and this question focuses on a very important topic in the world of estate planning, and that is assets which can pass according to beneficiary designation. At my office, a big misconception I see is thinking that a will dictate what happens to all of your assets. This is actually only true if you don't own any assets with beneficiary designations or you haven't filled out the beneficiary designations on any assets at all. Some assets require you to fill out those beneficiary designations when you enroll, such as an employer-sponsored retirement plan. So things like insurance policies, IRAs, retirement plans, and some bank accounts can be designated as payable on death or payable to someone, what they call a beneficiary designation. So with bank accounts in Wisconsin, we'll often refer to this as a payable on death designation, or POD for short. For retirement plans, financial accounts, you'll hear the term beneficiary designation. But the key thing to understand is that a bank account with beneficiary names would not necessarily be a probate asset. So probate is the court-ordered, court-administered process of proving your will and passing the assets to the people you name in your will. Or if you don't have a will, according to the statutes on intestate succession. But you can opt out of probate on certain assets, and bank accounts are one example you can do so easily. And the law in Wisconsin says you can make accounts payable on death, meaning this becomes a matter of contract between you and the bank. You put that form on file, pay on death the amount in this account to the following individuals. Now, to do this, generally the person needs to be an adult, so I don't recommend doing payable on death accounts for a minor. And if you're using a trust plan, I recommend using the trust to flow all the assets according to one vehicle. It makes it simpler and less confusing. But the concept today, the question is, do bank accounts with beneficiaries have to go through probate? And the answer is no. They would be over here considered a non-probate asset, and then your house, vehicles, personal property, assuming you don't have a trust or anything else set up, that would be probate assets that would need to go through the will. So when you're looking at your estate plan, think about probate versus non-probate assets and how many assets do I have of each type. Now, for many of my clients, they have significant assets in both pots, and that's why we often look at using a revocable living trust, because it's so flexible. We can use it to pass real estate. We can use it to pass untitled tangible personal property such as clothing, artwork, jewelry, guns, things like that. And we can also use it to pass bank accounts, non-probate at death, and avoid the time, expense, and fees of probate on all of those assets. But for today's question, it is possible to pass a bank account with beneficiary designations, and then they would not have to go through probate. And if you're the type who's thinking about avoiding probate, it's a smart decision often to do that because you can avoid the probate court fees on the assets in that bank account. So if you have a lot of money in the bank, if you don't designate beneficiaries and you have it pass under your will, then that would be assessed the fees to pass through probate court. However, let's say you have just one child and you want to designate them as the beneficiary. That would pass outside of probate and outside of the fees if you do it properly. If you use these beneficiary designations, I recommend you always make sure they're updated and consistent with your overall estate plan. So great question, and thank you for asking. Thank you for tuning in, and we'll see you next time.